Hello, Cybersecurity Law class. In this unit, we are going to circle back to something that we touched on in the Cybersecurity I class, and we're going to flesh it out a little bit more and pursue it actually over the next 2 weeks, which is the question of international human rights in cyberspace. And we're really going to, this week, focus on kind of Western democracies, and next week, next unit, we're going to focus on countries outside of the West. And one of the themes that you want to think about here, that we've thought about already a little bit in Cyber 1, but we're going to dig into more here, is the internet is obviously a key part of our democratic infrastructure. It facilitates speech, it facilitates communication, it facilitates culture, and is just a basic support of how we run our societies in a democracy. But we have this problem. In this kind of open network with this kind of originally utopian kind of vision for it, we have the problem of terroristic speech and recruitment for terrorist activities, and we have the problem of hate speech, and we have problems of fake news and propaganda. And we've already been looking at this semester the question of surveillance as it relates to national security and the problems it raises in internet surveillance. And we really want to begin folding in the question of what is the role of the big technology platforms. This is obviously the big debate that is in the news almost every day these days. What is the responsibility of Facebook, of Twitter, of Google, of Instagram, of these platforms that are allowing user content to be put out there and that are often being, they're being used often for very good discussion, but that are often being manipulated by bad actors? And should they have any legal responsibility in this domain? Now we'll talk a little bit now about the U.S. framework and then some of the frameworks in Europe. But as we're talking about this, keep in mind that the next unit we're going to be talking outside the West, meaning Iran, Saudi Arabia, countries like that where there is really North Korea, Russia, where there's really hardcore internet surveillance and censorship. But one of the things I want you to think about is how different really are the problems that we face here in the West, and how different really are the potential legal solutions, as it really pushes our thinking about this intersection between liberty and security. The key place where this is debated here in the United States now is in Section 230 of the Communications Decency Act. So then I gave you the whole section of Section 230 to kind of skim through. But the key provision is the one here on the screen. So this is saying that a provider of an interactive computer service is not to be treated as a publisher of information provided by someone else. And what this effectively is doing is saying that if you're a platform like YouTube or Facebook or Twitter or so on, you are not responsible, you're not legally responsible as a publisher for user comments. This was rightly viewed as a really important legal provision of immunity in the early days of the internet in the late 1990s and early 2000s, because there were some early cases when the internet really first became a public thing, in which website providers, web bulletin board providers, and so on were being held to be publishers of defamatory content posted by users. And so if you are the publisher of defamatory content, even if you're not the person who spoke or authored the content, you also are liable for publishing the defamation. So a newspaper, a television news network, if they are publishing defamatory content, they're commentators, their writers are defaming somebody else, they're going to be liable for it. And that's a feature of defamation law. It puts a burden on the publisher to engage in a kind of self-censorship, a kind of self-checking, to try to use journalistic standards to ensure that the content, editorial standards to ensure that the content they're putting out is accurate and is not defamatory. Because remember, truth is a defense to defamation. If you say something truthful, it's not defamation, it's truthful. So this was viewed and still is viewed by many internet advocates as a fundamentally important piece of the way the user-generated internet functions. And the thought is that to the extent users are saying things that might be defamatory, or if we can extend it into our discussion now, that might be fostering hate speech, or that might be fostering terrorism, or that might be fostering unlawful sex trafficking, that the user should be liable and not the provider. So there's been a lot of pushback against this provision in different discussions in the media and in different political circles, and particularly some conservative political circles. There's been some real pushback against Section 230. One place which that pushback has borne some fruit is in the Stop Enabling Sex Traffickers Act, Cesta, and the Allowing States and Victims to Fight Online Sex Trafficking Act, FASTA. So Cesta and FASTA were passed together in 2018, and I also gave you the text of those bills to read. So there was a huge push by many in the cyber civil liberties community to stop Cesta and FASTA from becoming law, and there still is a lot of debate about it today. And if you kind of Google it, look it up, do a little research on it, you'll see some of that debate. There's some arguments that it's having adverse costs and effects on some internet platforms. There's arguments that it's hurting sex workers, who it's not really designed to hurt them. It's designed to help people who are caught in that don't want to be. So there's a lot of debate about it. So what did Cesta and FASTA actually do? So the main pieces of it, for our purposes, is that it establishes that Section 230 is not meant to provide legal protection for websites that are facilitating prostitution or sex trafficking. And a lot of this comes out of incidents that happened involving sites like Facebook or sites like Craigslist, where people were trafficking other people against those people's will, and creating problems with that. So it's stating that intent, and then it's amending the Communications Decency Act to say that nothing in Section 230 should be construed to impair or limit any charge under sex trafficking law. Now, so what is the actual practical implication of that? Not entirely clear. Some backers of Cesta and Fasta have argued that the arguments against Cesta and Fasta were really overwrought because Cesta and Fasta really weren't enacting any very significant change in sex trafficking law. It was just kind of eliminating a possibility at the margins of a potential defense by sites that are really set up and intended to be promoting human trafficking. Whereas a site like Facebook or YouTube, that's not what they're intended to do. They have policies against that. It does happen, but when it happens, it's against their policy. The opponents of Cesta and Fasta pushed back on that and said, well, if that's the intent, you don't need this. And we really don't believe you, and we think the intent is really to put some more pressure on these other sites. Well, what does federal sex trafficking law look like? We have 18 USA 2421A, and notice that this is talking about using some facility of interstate commerce, including an interactive computer service, with the intent to promote or facilitate prostitution. So the mens rea requirement here is that there is a specific intent to facilitate prostitution. So the supporters of Cesta and Fasta would argue, that's a specific kind of intent. It isn't going after sites that sort of aren't intending to do that, but some of that activity might be on the site. This portion of 2421 is basically the same idea, but notice it's bumping up the crime for trafficking of 5 or more persons. So it's just a higher level of a crime for more persons, as well as for the use of force or threats of force, forcing someone into this kind of conduct. There's another federal sex trafficking statute that relates specifically to the trafficking of children, which is 18 USC 1591. Now here, I think, is a place where some opponents of Cesta and Fasta push back on the notion that the federal sex trafficking statutes are all about a very specific mens rea for the site as a whole to be promoting unlawful sex trafficking. Because notice that this statute applied to children includes the act of recruiting, enticing, harboring, so on. So the actual act itself of involved directly in trafficking, or benefiting financially or receiving anything of value in that kind of trafficking venture, knowing or in reckless disregard of the fact that these kinds of actions are happening. And it's then defining participating in the venture to mean knowingly assisting, supporting, or facilitating the violation. So here there's a major debate and question. If a site like YouTube or Craigslist or Facebook has what is called red flag knowledge, so in other words, not necessarily actual knowledge of a specific instance, but knowledge from the facts and circumstances that's enough to infer that this kind of activity might be going on, does that then make them knowing or at least in reckless disregard and benefiting financially from that participation? And there could be an argument that that could be the case. And there could be an argument that if a sort of general social media platform is not adopting specific measures to try and identify and root out and eliminate this kind of activity from its site, if it's just sort of closing its eyes, that willful blindness perhaps might be enough to meet this reckless disregard standard. And that's one of the big questions about what effect Cesta and Fasta is actually having on these sites. Now, you might say, as a policy matter, that's okay. I actually want those sites to have that kind of legal obligation, or at least to have, even if it's sort of a remote possibility that they might be criminally charged under a provision like this and that charge might stick. But if that's even enough to incentivize them to at least begin some action to try and identify instances of child sex trafficking, then I'm okay with that. I'm happy to put that obligation on those sites. They play a certain role in our society. They make a lot of money playing that role, and they ought to bear that burden. So you might say that as a policy matter. And this is what we'll discuss in the discussion forum this week. You might say, as many open internet advocates say, yes, I agree with the deep concern about child sex trafficking. We all agree that's a horrible thing. We all agree that there's at least a moral obligation for a site like Facebook to try and make some effort to police some of that. But we don't want to go down the road of putting these sorts of fuzzy legal obligations, not to mention hard-edged legal obligations on these sites. It's just too important to the functioning of the open internet that we preserve the integrity of Section 230. And there are other ways in which there can be sort of voluntary programs and other ways that these sites can be good corporate citizens and work with law enforcement on these really sensitive matters. But we don't want to have liability, much less criminal culpability, for these sites. That's really the heart of the debate in the U.S. Now, we have Cesta and Fasta. There has been a lot of discussion about similar provisions for other things. One of those things being terrorist content. So there's a lot of debate in Congress, and especially some conservative lawmakers have suggested there should be some specific provisions limiting Section 230 with respect to the availability of terroristic content. So no, that's there. There have also been proposals like this one, and in the U.S., proposals relating to terrorist content have not gotten any way along the line to being passed into law. So none of them are law. There's also been a lot of debate about whether social media sites like Twitter and so on are censoring conservative voices, either sort of directly, intentionally, or by tweaking their algorithms in a way that are likely to put conservative commentary toward the bottom of people's social media feeds. So this was an example of one proposal that would suggest that a site would lose entirely its Section 230 immunity unless it obtained a certification from the government that it was acting in a non-biased or neutral manner. This also was not passed into law and did not get sort of anywhere down the road toward being passed into law. But it raises the question of, again, of what role we see these sites playing in our society. There are some rules like this for broadcast media that is playing a kind of news journalism function in order to get a broadcast television license, or under the cable television laws, there are some requirements about carriage laws and so on. None of them required the kind of certification that's talked about here, but there are sort of rules about it, and they do get policed by the FCC. We don't have those rules regarding the internet because of the different history of how internet regulation, or the lack thereof, developed. Broadcast radio deals with radio spectrum, and there's interference on radio spectrum, so it's a scarce resource. Broadcast television also deals with spectrum. Cable television doesn't deal with spectrum, but initially the kind of bandwidth, the actual ability to lay cable was more limited. So, and you had to lay the cable over public easements. So in all those cases, the broadcasting companies, the media companies, are viewed as getting some kind of license from the government, and in return for that license, they take on, at least some limited obligations of fair carriage and public access. By design, regulation of the internet, when it first became an issue in the mid 1990s, was to say we're going to treat the internet differently. We're going to regulate it with a very light touch, and we're not going to view it as this kind of scarce bandwidth resource, and we're going to allow it to develop from the ground up and to sort of police itself, to censor itself. So within that regulatory framework, we don't view Facebook and Twitter and so on the same as the New York Times or CNN or an organization like that. And the question is, should we? And should the law view them that way? Or should the law sort of retain this stance of, no, that part of the world really polices itself? One of the very interesting things about this debate is that really the US is the only Western democracy that has a law like the CDA Section 230. The EU does not have a CDA Section 230, and other Western countries do not have a CDA Section 230, so that content platforms in those countries can be legally responsible for content posted by users. Some people argue this is an important feature of the difference in U.S. law, that it attracts these media companies to be based in the U.S. and fosters U.S. competitiveness in that sector. That may or may not be the case, but that's kind of the argument. I gave you to read, and we peeked at this also in the Cyber 1 course last semester, the way the EU has viewed cybercrime and hate speech and terroristic content. So this 2003 rule in the EU requires every national government within the EU to adopt criminal legislation that requires distributors, and not just the speaker, but the distributor or publisher, which can include a social media site, to not make available racist and xenophobic material, and provides certain remedies for it. It also does provide, as you can see, some exceptions. It does allow a national government to not have this kind of law if the free speech principles or freedom of the press principles in that country would require it. But it does establish in EU policy that, generally speaking, there should be this kind of rule. It also creates a criminal offense for racist or xenophobic threats to commit a serious offense. So the Article 3 provision here is about generally distributing hate speech of any kind. The Article 3 provision is hate speech that contains a specific threat. And for the specific threat, there are no exceptions. Every EU member country has to have this law. Article 5 of this protocol covers simply insults, and that provision is optional for each EU member state to adopt, but if a state doesn't want to adopt it, they have to apply with the European Commission to not adopt it. Now, in 2018, the EU issued guidelines for how social media sites should deal with illegal content. And illegal content would include the kind of speech that we just looked at, xenophobic speech, hate speech, terroristic speech. These guidelines, which I also gave you to read, were not binding rules, so they're not law. But they can be viewed as sort of an initial step, possibly toward something that becomes a more binding rule, depending on how the social media companies comply with or don't comply with these guidelines. So, the guidelines have a number of important features. One of those features is that the platform should give notice to law enforcement when it finds illegal speech on its site. So that means that there's some kind of obligation, and including proactive technologies, right, technological tools that is going to enable these sites to flag this kind of content and then to notify authorities when that content exists. One of the really sort of controversial things in these guidelines is this 1 hour rule. So the idea here is that when there is terroristic content, the platform is supposed to, within an hour of detecting that content, refer it to the authorities. And then connected to that is the second bullet here, which is faster detection and effective removal, which is the idea that these sites should be using automated detection. So a combination of automated detection and 1 hour referral. So what's automated detection? Automated detection is artificial intelligence. It's talking about data analytics and machine learning to identify this content. Now, so you could look at this, of course, from various angles. I mean, you can say this kind of content is a real problem. It's one of the key ways in which a group like ISIS, for example, is recruiting people, or in which groups like this are communicating among each other to coordinate or stage an attack. And it's a relatively small number of users of these sites, but it's a big problem. And it's a good thing for official government policy to encourage these platforms to take steps. You could also see it as potentially dangerous, especially when you're talking about automated machine learning. We tend to have a bias toward thinking that that kind of system is going to be more accurate, but those systems build in their own biases. And so there's a worry about content that is simply political speech or religious speech or other kinds of innocuous speech that is not terroristic at all, getting flagged and weeded out by mistake. So what's the sort of burden on freedom of culture and religion and freedom of speech going to be? And that's the big debate. The EU puts out these really nifty infographics often on their policies, so I just thought I'd give you this infographic which the EU put out, which reiterates what the policy is. Many of the member states within the EU also have their own national laws, maybe in part implementing some of these EU protocols, but also reflecting their own national views about this kind of content. So I gave you to look at the Germany NetzDG law. I didn't give you the French law, but I'm going to talk about the French law as well. Now, one of the really interesting things about countries like Germany and France and other European countries, especially on the continent of continental Europe, they are working against the backdrop of fascism and World War II. And certainly for Germany, there's this enormous national burden in the law to deal with the legacy of Nazism. And the same thing is true in France, because of course, France was occupied by the Nazis, and many of the French authorities collaborated with the Nazis. So there's a very different view in those countries about the limits to freedom of speech that they're willing to tolerate against that backdrop. And of course, each of these countries have their own contemporary struggles with resurgent, ultra right-wing extremism, neo-Nazism, as well as with threats of terrorism. So the NetzDG law applies, as you can see here, to all internet service providers and social media platforms, and it requires those platforms to have a procedure to handle complaints about unlawful content, and it requires them within 24 hours of receiving a complaint to block manifestly unlawful content, and within 7 days of receiving the complaint to block unlawful content. So that means that the an internet service provider or platform or media company in Germany, operating in Germany, has to have people who are able to make a call about whether they believe certain content is manifestly unlawful or unlawful, and then to block that content. The NetzDG law defines unlawful content, and it refers to certain sections of the German criminal code which criminalizes certain kinds of speech. And notice that first one there, Nazi symbols and propaganda. So here in the U.S. it is not a crime to display a Nazi symbol, and it's not a crime to sell Nazi propaganda. That is protected by the rights of freedom of speech. Of course, somebody might do that out of some historical interest, as a collector of World War II buff. Other people might do that because they are neo-Nazis. Now, it is, of course, a crime under U.S. law, or can be a crime under U.S. law, to incite violence. And so, U.S. law enforcement authorities do watch these ultra right-wing neo-Nazi type groups, to see if their speech and their propaganda is moving through that fuzzy space of being protected speech to being incitement to violence. And if it's incitement to violence, action can be taken. But in Germany, simply displaying a Nazi symbol is a crime, right? And so that just reflects this different history of, with fascism and World War II. So you can see a number of other things here. One I want to call your attention to is this incitement of hatred against a group. Again, and then a little further down, defaming the religion or ideology of another person. So all of these things obviously are against the backdrop of the Holocaust. So now again, in the U.S., it is protected speech under the First Amendment to say ugly things about someone's race or someone's religion. It might be distasteful to do that, it might be immoral to do that, but unless it's inciting violence, it can't be illegal. There are also some questions about, what is incitement of hatred or defaming, and what is sort of just legitimate criticism or critique. And those are sort of difficult lines, and they're even, in some sense, even more difficult under a law like this, because here we would say that is a kind of line of taste or a line of morality or something like that most of the time. But in Germany here, it's a line based in the law. So here you can see some of the fines, and you can see that the provider has to designate an agent for service of process in Germany. So what does that mean? It means there must be a direct line between the provider and the government. It facilitates a degree of government oversight of what the provider is doing, so that the provider is directly responsible to the authorities. So here are some aspects of some of the law in France. I didn't give you any of these to read, but one thing you want to note is France, over the past 5 or 6 years or so, has really been having a major national debate about anti-terrorism laws. So on the one hand, there have been really devastating terrorist acts on French soil. So there's the Charlie Hebdo attack. There was the attack at the French nightclub, and it's a real problem. On the other hand, there are tensions in France that raise really difficult and ugly questions of racism, as well as of France's colonial past, because of immigration into France from North African countries of Muslim people. And throughout both France and Germany and throughout Europe, there's this big debate, which is, as you probably know, which has its differences, but also its sort of parallels with debates about immigration in the U.S. So debate about immigration, but in France and Germany and other parts of Europe, it tends to be about Muslim people from North Africa. So that's the backdrop of making this a really fraught and difficult thing. So this 2014 anti-terrorism law, bans Holocaust denial. Again, that in the U.S., that's as insane and ugly and immoral as it is to deny the Holocaust. It's free speech, and you can say that if you want to. So you can't even say that in France. So Nazi memorabilia and so on. One of the key things here is France has a government office, this OCLCTIC office, that has authority to make requests to an internet service provider or social media site to remove certain kinds of content, and requires the sites to respond to those requests. So it places a legal obligation on these sites to give a response, and either to block the content as requested or to justify why the content doesn't have to be blocked. So we don't have anything like that here in the U.S. The government can can serve subpoenas and gather information from these sites, and to the extent that a platform was directly engaging in sex trafficking or something like that, Cesta or Fasta might kick in. But most of the time, what U.S. authorities are doing with respect to the social media platform or the ISP is to get the information needed to go after the individual or group that's perpetrating the act. Here, there is a regulator that is able to regulate also directly the sites. Now, you could say maybe this is a good thing, and maybe we need this here in the U.S. Maybe the role that these social media sites are playing requires that they have a regulator. After all, broadcast television, cable television, radio, they have regulators, and that regulator is the FCC, and there are decency and other kinds of rules like that. But you'll also see next unit, when we talk about internet surveillance outside the West, that having a central regulator to monitor content and to be able to make legally enforceable requests for content to be taken down is one of the key ways in which dictatorial countries control their internet. So that brings us to the Australia Sharing of Abhorrent Violent Material Act, passed in 2019, and we did look at this a little bit in Cyber 1 last semester, but I want to bring it back into the conversation here. So recall that this is a 2019 statute. It's passed after the Christchurch, New Zealand terrorist attack, mass shooting, which was live streamed on Facebook and was recorded and then sent around YouTube and other places. And so this statute covers material of violent conduct that records or streams that kind of conduct, and makes it a criminal offense for the ISP or the content service provider or hosting provider to fail to notify authorities and to fail to remove that content. So this puts a very specific criminal legal obligations on the site hosting the content, even if it's a otherwise neutral site like a YouTube or a Facebook. All right, and here's the language about the fact that they've got to expeditiously remove it, and there's a recklessness standard for being able to detect the material, which is really going to put an obligation on these providers to use automated processes and to have staff that can find the content. A few exceptions in this statute for certain kinds of research or certain kinds of artistic work. So there is some effort to nod toward free speech type values, but critics of the Australia law would say that it's those don't go don't go far enough, and you really shouldn't be going after the provider. You should be getting the information from the provider and then going after the perpetrator. But again, others will argue, and obviously it became law in Australia and won the argument that no, these providers are really the front lines. They really have the ability, have at least some ability, to weed this out at the start, and they should have a legal responsibility. And that's really the debate. So this should give you a bit of a feel for the differences between how we view these issues, or have viewed these issues in the U.S., the current debate within the U.S. over Section 230, and how some of these issues are viewed in Western democratic countries outside the U.S. We'll talk online in the discussion forum about Cesta and Fasta, and then next week we'll look at how countries outside of Western democratic countries control their internet and some of the steps they take, and we'll kind of compare and contrast the steps they take from some of the steps taken in some of these Western countries, and really then kind of dive into the difficulty of how, even from the perspective of a Western democratic country that values the human rights of freedom of association and freedom of speech, how to manage the real problems that arise in this space.